Hi there. This is Dr. J. Kent Gregory, and welcome to Chapter 4 of the Legal and Ethical Environment of Business. This is the chapter on alternative dispute resolution. So this is actually where we depart from the background of how courts and the Constitution works and how all that's set up to actually things that are used and have direct impact on businesses. Well, let's continue. Get into it. So alternative dispute resolution, so ADR, encompasses many different methods of dispute other than litigation. So these include negotiation, mediation, arbitration. So negotiation, mediation, and arbitration. And the Federal Arbitration Act, so the FAA, is a federal statute under which parties are required to participate in arbitration when they've agreed to do so by contract. So that you'll find that a lot of B2B, so business to business contracts, or even business to employee contracts, have an arbitration clause in it. So if there's a dispute, that's the first recourse is arbitration. So here's the ADR continuum, and this is a nice way to look at uh, the kind of the spread between, let's say, informal and negotiation on one side to the more formal and more strict, litigation on the other side. So here, parties decide the outcome and they retain control over the process. On the other side, they are under the control of the courts, so they cede control to the jury and the judge. And the neutral, which is the jury or the judge, decides the outcome, or the jury and the judge together. So in between here, you have facilitation, you have mediation, where there's going to be a third party. Typically, there'll be a third party with these as well. And then you get into arbitration, and then that's the last step or the kind of the last point on the continuum before we get to litigation. So a key takeaway. So ADR is a body of dispute resolution methods outside of the litigation process. So ADR is often faster, and a key component, particularly for those of us who are in business, is it is much less expensive. You're not paying court costs, and you are not paying legal fees. So kind of a typical legal fee, you're looking at 400, $300 an hour, and that will be even more when you're in larger cities and maybe a bigger company, that you would have, those fees would be even more. And anyway, it's also more private, so it's not in the courts, not before the public. So a lot of people will go with ADR rather than litigation. Um, However, some types of disputes might be best resolved through litigation, such as in cases where parties have unequal power or resources. So you often find this where the employee doesn't have the power or resources that his or her employer has. And so we talked about negotiation, mediation, and arbitration. And mandatory arbitration clauses are common in contracts. And such clauses are enforceable against the parties, even if they wish to litigate their claims. So basically, a mandatory arbitration clause says you have to go to arbitration if there's a dispute. So some negotiation. So the book sets up an example of non-conforming goods. The non-conforming goods are goods that don't conform to the buyer's order. So under the UCC, non-conforming goods can be rejected by the buyer. And very often we'll see negotiation or arbitration about non-conforming goods. So uh, the negotiation can be B2B, so business to business, and negotiation is often seen as a win-win ADR strategy. So this is where both parties try to reach a mutually satisfactory outcome. So negotiation requires the parties to define the conflicts and to agree to an outcome to resolve those conflicts. So some benefits, it's speedy, It's inexpensive and it's voluntary. Some drawbacks is there really are no set rules, and either party may bargain badly or unethically, and there's no guarantee of resolution. The non-involvement of attorneys can be seen as a drawback or a benefit, depending upon the circumstances. And then finally, memorialize. This is to capture the verbal understanding into a written agreement. So when a resolution is reached, it is memorialized in a written document that is often converted to a legal judgment. So, alternative to a negotiated agreement where it's not win-win, some things to think about are these acronyms. So, BATNA. Uh, this is uh, this is a acronym for Best Alternative to a Negotiated Agreement. So there we go. Best alternative to a negotiated agreement. And this is used by negotiators to ensure that favorable terms are not rejected and unfavorable terms are not accepted. So this, when you go into a negotiation, whether that's for business or whatnot, this is something to keep in mind. When you get into the negotiation, what is your BATNA? And then the WATNA or the WATNA, this is the worst alternative to a negotiated settlement. Um, and this is also a concept used by negotiators. So keep this in mind. What is the worst? And then finally, that allows you to identify both of those theories or terms allow you to identify the bargaining zone. So this is an area in which parties to a negotiation are willing to trade, barter, or negotiate their positions, within which both parties can find an acceptable agreement. So this is your bargaining zone. So where is that? So this is something worthwhile to think about, not just in, again, not just in business law, but in regular negotiations that you may have, in your life, say with your children. Anyway, a reservation point. This is your bottom line. Yeah, so these are some things to keep in mind. Um, so key takeaway here, negotiation is an alternative dispute resolution in which the parties retain power to decide on the resolution of the issue themselves. Um, so sometimes it's used where there's no legal dispute. And it's very often the first method of dispute resolution. Negotiation between the parties with unequal bargaining power can result in the stronger party being kind of heavy-handed at the negotiation table. So we know what that could mean. So, but to wrap it up, negotiation office is often considered a dispute resolution option that can result in a win-win situation for all the parties. So that brings us to an end of part one.